Hi, this is attorney Marie Martin of Martin and Hedevar PLLC, and today's topic is lease terms to consider when you become a renter. If you're a first-time renter, you'll want to think carefully about the terms of the lease you are about to sign. A lease is a binding contract with the landlord. A lease can be oral or written. You should review it thoroughly before you sign it and consult someone before you sign it if you're not sure what something in it means, because you will still be bound by it. It is a good practice to always have a written lease, and a written lease is required by Minnesota law if the building has 12 or more units in it. You should also get a copy of the lease after it has been signed by you and the landlord for your records. It is also a good idea to start a permanent file when you start renting, to put a copy of the lease that is signed by all parties and pictures or video of the entire unit you are renting before you move in. The lease will usually say how long it will last. Most leases are for a definite time period, like 6 months or 12 months. If there is no specific end date spelled out in the lease, Minnesota law fills one in and usually considers the lease to continue and automatically renew if neither party gives the other proper notice of the end of the tenancy. The lease will also usually state who is responsible for paying which utility bills. Things can get complicated if multiple units all share utility meters, so be sure to get copies of the actual utility bills from the landlord if that is the situation. Keep them in that permanent file with the lease and all of your move-in pictures. In a shared meter situation, your landlord must also provide you with a notice of the total utility cost for the building broken down by month for the most recent calendar year. You can use this as a guide to decide what size bill to expect while you live there. This would also go in your permanent file. If you're going to be responsible for maintenance and repair of the rental property, both parties should agree to this in writing, and you should require adequate consideration for taking care of that. If you do this, keep receipts for anything that you spend or buy in that permanent folder. When entering into a lease, a landlord cannot discriminate based on skin color, familial status, marital status, national origin, race, receipt of public assistance, gender, pregnancy, sexual or affectional orientation in Minnesota. If you think this has happened to you in the rental application process, contact the U.S. Department of Housing and Urban Development to file a complaint, and they should investigate further or refer you to a local agency that will investigate. A landlord may also be obligated to make a reasonable accommodation for you if you have a disability. You must show that you have a disability, request a change, and show how the change is necessary to accommodate that disability. A reasonable modification could be a change to the physical structure, but must not be an undue hardship to the landlord, and the tenant is responsible for the cost to change and changing it back. If you have any questions, send us an email at info@mhpllclaw.com.